several cases and tell you how I would remember it. The the um the main purpose of this video is so just to help you, well, to give you understanding and to help you have recall or associate the cases and to understand the importance, but to trigger your memory. So this case was Fisher versus Carousel, and Carousel was the name of a motor hotel. Fisher was the person it was about. So Carousel, to me, okay, you could think of motel, the L at the end of it, but just Carousel sounds like fun place, fun thing to do, and how you could, associate that with a motel. So at a professional conference held in the hotel, um, there was a black man who was getting ready to eat, and this is an intentional tort, and the person grabbing the worker there grabbed the plate from the hand. He was holding a plate getting ready to fix his plate, and this was back, let's see, let me get the date for this. Okay, so it was 1967, and going back here, what happened was that he was holding a plate in his hand, getting ready to fix his plate, and the staff grabbed the plate and said a Negro could not be served in the club, quote. So the employee did not make physical contact with the plaintiff, but the event was witnessed. And I think this is an important case for, okay, so what happened is that the plaintiff sued for assault. The rule of law is that a plaintiff may recover for battery even when not physically touched, so long as the defendant committed an unwanted and intentional invasion of the inviolability of the plaintiff's person. So if even if they don't actually physically touch your person, if they touch something else that's touching you with malintent, intentional invasion in this case, it can be ruled, you can get damages for assault and battery. So, I think this is important. Like, say somebody has an earpiece in and they are talking with someone else, getting all riled up and angry. Maybe that person's incapacitated on drugs, drunk, and you want to know who that person is talking to. If you touch the earpiece, of course, you would have to show intention to harm. So that would be important. Not just that you touch it, but that you show an intentional invasion of the inviolability of the plaintiff's person. So, if that ever happens to you and you get in a situation where somebody threatens to have you arrested for assault and battery, make sure your intention was good, that you weren't intentionally trying to invade the privacy of another person, but you were just trying to de-escalate the situation. So you can actually hold someone who has touched an item that the plaintiff is touching, and with intentional invasion of privacy for malintent. So unwanted and intentional invasion of one's person through dispossession of an object is battery, even in the absence of physical contact. So I think that's a good thing to know. Actual damages for mental suffering stemming from battery may be awarded even when no physical contact is made. All right, so that's one. And like I said, you can think of the L hotel, the L in hotel, was a motel, and also like a fun. Think of hotels as a fun place. The next case is Blyth and Birmingham Waterworks, and you can remember this because of Waterworks, because that's what it's about. It's about a really cold winter where this fire plug doesn't work right, it gets clogged, and it messes up property. And so the waterwork company is sued, but did not win because it was an unusually cold winter, and the company had been diligent before to protect it, but it was unforeseeable how cold this winter could be, so therefore they were not held liable for damages. So it says one of the hydrants across from the plaintiff's house developed a leak, and as a result of exceedingly cold temperatures and caused water damage to the house. Plaintiff sued for negligence, and the synopsis of rule of law is negligence is a failure to do something a person of ordinary prudence would do, or the taking of an action that a person of ordinary prudence would not take. So a mere accident that is not occasioned by the failure to take such an action or the taking of such an action does not qualify as negligence. So it was argued that it was unforeseeably cold, exceedingly cold. The fire hydrant, the plug, had been installed 25 years prior, so that's how long it had gone through weather, and it was caused by the extraordinary cold, unforeseeably cold weather. Prior to the incidents, there had not been any problems with the plug, so they would have had to show that. The jury was allowed to pass upon the question of the defendant's negligence and return a verdict for plaintiff. So, so the verdict was entered for the defendant. No evidence was entered showing any acts of failure. The evidence showed that they routinely took precautions. So make sure if you have any kind of business that you are taking precautions, or just in your regular house, in the houses that you have, property, any that you have, make sure you are doing your due diligence and caring for your properties or your business elements. So the court distills the essence of basic negligence: the mere fact that someone has been injured by another at another's property does not mean negligence has occurred. Rather, one must act or fail to act in a way that someone of ordinary prudence would not act or fail to act. Okay, so it was not foreseeable that it would be that cold. Another case is Stubbs versus the city of Rochester, and it has to do with the water in New York there. What happened was that the city had two different systems, one for potable or drinking water, and the other one for putting out fires. And apparently there was fecal matter in the one putting out fires, and it contaminated the potable one. Stubbs drank that unknowingly, and as a result, con, con, was came down with typhoid and sued the city. And the importance of this case, oh, and you can remember, I remember Stubbs typhoid. I put the typhoid and the ST, that together to help me link that. And the final decision was that New York was responsible because you just have to prove a new standard. You have to. It resulted in a new standard that says you just have to prove to a reasonable degree that it caused it. So that was what was significant about that case. Like, you don't have to prove it exactly, but to a reasonable degree. Then another case was Wagon Mound, and this happened because there was this ship who, in a broken pipe, leaked oil into the water at a dock, and it went over to this other dock where there were workers, and some of the cotton, sparks of cotton, fell into the oil on the water, and there was a fire. Okay, so there was a fire, and damages. People were hurt, and what was important about this case is, so would they be held? Would the ship where the oil spilled, be held responsible? Were they negligent not to warn people about this oil spill? But because the common opinion at that time is that it wouldn't catch on fire. It said previously the English courts ruled re polymus. I'm not sure let me see if I've got that right. Okay, so I did spell it right. The key point is, if a reasonable man would have foreseen any damage as likely to result from his act, then he is liable for the direct consequences that are suffered. So the problem with holding him accountable for this is that that was not the general opinion. The general opinion is that it couldn't burn if it spilled in water like that, so therefore the reasonable person wouldn't have warned anybody, because that was the common understanding at the time. So it's about how remote to the actual damage being caused is the action that you're trying to hold the defendant liable for. So the issue, the defendant, was he negligent even though the damage wasn't foreseeable, and the extent of liability. It used to be, it was broader than that. That it used to be broader, saying that you pretty much have to be, you're liable for any damage caused by an action. Okay, so re polymus was a broad principle that if you're negligent, you are liable for all direct consequences, even if the type or extent of the harm wasn't reasonably foreseen, as long as some damage was foreseeable. But they could argue that it wasn't foreseeable because that was not the common knowledge. So the importance of this case is that it limited the scope to a level of remoteness that could not be foreseen. So it limits the negligence, and the damage was not recovered in negligence. The scope of the duty is limited to foreseeable knowledge. So in summary, we talked about Stubbs versus the city of Rochester, which was the typhoid. Remember Stubbs, typhoid. Wagon Mound. Perhaps you could think of a wagon full of cotton. I mean, that's something that I could connect. That I don't know if other people could, but connect the wagon with cotton, and then that'll help you remember the sparks of cotton falling on the oil spill. Then there was the Waterworks, which was the fire plug that was not that was clogged due to unforeseeable. So there they weren't held responsible. They weren't held negligent. With the typhoid one, it was all you had to do was prove uh, a reasonable degree. The standard was a reasonable degree. With the um, with the situation with the city of okay, so we talked about the Wagon Mound case where, remember, like uh, the Wagon Mound case, which had to do with the sparks of cotton, and they were not held liable because the question was how remote is the damage from the cause, and that you have to. They were found not liable, didn't have to pay damages because it was unforeseeable that it could catch on fire at all. The other case was the Stubbs and typhoid. I put it together. Typhoid, and the city was found liable in the end, or it did have to pay damages because, or negligent. They were found negligent because they did not, because they proved it, that there's a reasonable degree. They proved it to a reasonable degree. Then there was the Waterworks one, which they were not held liable because they proved that they had been doing preventive practices and maintenance to a reasonable degree, and it was unforeseeable how cold it got at the time. And then the last one I did was the Carousel one, where you could be charged with assault and battery if you have intentionally invade someone's space and aggressively treat any object that is touching them with intentional invasion.